Hi everyone, and welcome to our webinar on duty of care, litigation, beware of your supply chain liability. We're very happy to have you all here today. I want to give a really special welcome to our panel, first and foremost. So firstly, we have Ziade from Paris-based firm Fierville Ziade. Mariod acts for French and international clients and DNOs in litigation and arbitration proceedings. And she's got a lot of experience in the topic of the duty of care. Also worth noting that prior to setting up her firm, Mariod also acted as in-house counsel for a number of large corporates, including Amazon, and she headed up the dispute resolution department of Areva, now called Orano, which is one of the world's leading nuclear energy companies. Secondly, we've got Nicola Cobb from FTI Consulting. Nicola is a senior managing director specializing in investigations and business integrity. So Nicola helps clients manage their regulatory and reputational risks arising out of their extended operations and supply chains. So we're very happy to have Nicola with us today. And finally, Daniel, colleague of mine, Daniel Levy, is a partner at Enyo Law. Daniel also represents clients in litigation and arbitration proceedings, often representing Spanish, French, and Portuguese-speaking clients in Europe, the Americas, and Africa. And Daniel also sits as an arbitrator and as an expert. So a few quick housekeeping points just before I give a very brief introduction to the topic, and then we're going to dive straight into the Q&A. We're recording the webinar today, so we will share a copy of the recording with everyone that's attended. We only have an hour. We may be able to go over by 15 minutes or so if there's still lots of questions, but it's obviously a very big topic, so we'll cover what we can. And thirdly, if your question doesn't get answered today, or if you'd rather write to someone in the panel directly, please do so, and we'll obviously get back to you as soon as we can. So why did we pick this topic, supply chain liability? Why do we think it's so important? I think the reason is that businesses today, more than ever, operate with complex and increasingly lengthy supply chains. And we want to discuss today why that matters, what risks this presents from a litigation perspective. And we're going to be looking at the UK perspective, but also the French perspective and the European perspective, and some of the other jurisdictions such as Brazil. We're seeing more and more cases coming to the European courts and the UK courts for harm that is suffered or occurs overseas. Many people listening today will be familiar with some of the most high-profile cases dealing with environmental harm. So, for example, the £5 billion class action against BHP, the mining giant. And that claim relates to the collapse of the Fundão Dam in Brazil. But significantly, that claim and the defendants to that claim are companies in the multinational group that owned or part-owned the owner and operator of the dam in question. And today, what we want to do is look at how the scope of liability might be extending beyond that business equity relationship to other triangular relationships. So we want to explore whether a duty of care might exist in a relationship between a purchaser and a supplier, or between a financial institution and a borrower. So to do that, we're going to look at some cases. I'm going to talk very briefly through a Dyson case, which is a claim at pre-action stage brought by Malaysian factory workers against Dyson's UK subsidiaries about a factory in Dyson's supply chain. And I'm going to talk about the Moran case, which shows that the UK courts are willing to entertain a claim against a UK company based on a duty of care where harm is caused by a third party in that company's supply chain. Once we've had a look at some of those cases, Mariod is going to talk about the French perspective as well, what's happening in France. She's going to talk about as well the EU proposals on corporate due diligence and why they matter. And really, Mariod is going to try and paint a bit of a picture of what the legal landscape might look like for European companies and also for companies that operate in Europe very soon. Nicola is going to share her experience of working with corporates, helping them manage these growing risks and looking at how they might minimize the risks arising from supply chain activities and third parties. I should say that many of you might have noticed that we unfortunately don't have one of the members of our panel today. Kai Carl unfortunately wasn't able to join, but Mariod has got a lot of in-house experience and has kindly offered to talk today with two hats on. So she'll be speaking as both the in-house practitioner, as both the in-house expert and also as the practitioner. I think just to draw a conclusion on the introduction, what we will see probably is from the cases and the legislation that ESG doesn't stop at the corporate veil. We're going to be seeing the trend in the courts and in the legislation towards mandatory reporting and towards corporate due diligence. So if not today, then I think very shortly, legislation and courts will require companies, and particularly large companies, to be doing much more. So that's it from me for the moment. I'm going to hand over to Daniel, who's going to be moderating today.
Thank you very much, Anna. Thank you, everyone. First of all, let me introduce Anna, who didn't introduce herself. Anna is, of course, a colleague of mine who works with me at Enyo. And Anna is our, she's leading our ESG practice here at Enyo. We've been pioneering some of those cases, and Anna has a lot of experience representing clients in both arbitration litigation involving an ESG angle. And not only disputes, Anna is also with the team here working on all the parent company and supply chain issues to try to prevent also those claims. So I'll just, and I'd like to thank you, everyone. I shall confess, I've never been in such a successful webinar. We had 350 people registered, and we have like almost 200 people watching. So it's quite incredible, and I think that shows how important the topic is and how worried the companies are. And it's not one of these theoretical topics which we're going to discuss and it might happen. No, we already have on parent company liability around 10 class actions in Europe. Mario will certainly, say her number. Nicola might have her number, but this is happening. There are a growing number of class actions in Europe which are being brought for damages caused in other countries, either because the parties in Europe have a duty of care for their subsidiaries, even because, or what's in the sense of the EU directive, because the company in Europe is going to be accused of not having done a proper due diligence of its supplier in Brazil or its supplier in Asia, in Africa, or whenever and whatever. So I think this is really interesting because the idea here is to try to think about how we could, what are the criteria under a legal perspective, and also thanks to Nicola under a more factual. So what companies with, offices, subsidiaries, holdings, or simply investors, funders in Europe can do to try to avoid or to improve their due diligence in relation to the subsidiaries, to try to avoid that extension of liability from all those countries in Latin America, Africa, Asia, to their operations in Europe. So I will immediately turn to Mariod, so she can talk us a bit through what's the situation in France. So what's going on? I know France has been one of the pioneers. I don't know if it's good or bad, Mariod, but on the pioneer on those actions. And even if you think, oh, I don't have a branch, or I don't have an office in France, so I don't need, that part is not for me. It's important to know that both probably what's happening in France will be reproduced in the Netherlands, in Portugal, and as Anna will probably say, also in the UK. So France is a good example. That's why we are very happy to have Mariaude. And please, Mariaude, the floor is yours. And we thank you again for being with us and hosting also this webinar.
Thank you, Daniel. Thank you, Anna, as well, for this great introduction. We are very happy as well to co-host this webinar at Fierville, Ziade. As you said, Daniel, we are mobilized on this duty of care topic and already involved in cases with clients in France. So yes, I will not make a statement of whether it is good or bad that this French law was pioneered, but yes, we were. So in France, as soon as March 2017, a law was enacted which gave rise to a duty of vigilance on the shoulders of all major French companies, major being in practice those who employs more than 5,000 employees, or more than 10,000 employees if they are operating on the global market. So the duty which was created by this French law was to ensure that in all their activities, these major companies be vigilant to protect the health and safety of the persons, the environment, and the human rights. So you can see already that the scope is extremely large. We could have a single seminar on the definition of what are the environmental standards which are protected by the French law, or the human rights which are protected by that law. But the scope of this law is also very large in terms of the activities which are at stake, because the parent company in France is liable to ensure that not only herself, but also its subsidiaries in the world, but also all of its suppliers and subcontractors are vigilant to protect those rights. And the only limitation regarding suppliers and subcontractors is that they have, the law says, an established business relationship with the company. So in practice, you can see that for the largest companies, we are talking about thousands of suppliers or subcontractors in the world that the parent company must be vigilant to regarding the duty of care. So the objective of this French law duty of care was really to target the whole supply chain of the company and to oblige the mother company to provide preventive measures to avoid, to the maximum possible extent, the risk of violations of human health, safety, environmental and human rights standards. In practice, the law requires, and that's, as you said, Daniel, important because the the EU directive, which is currently negotiated, inspired completely on the French standard. So the French law requires that the company must report and publish each year what is called a vigilance plan, where it summarizes every preventive measures that have been taken. And what further distinguishes French law from other domestic laws which were enacted on the same topic is that it created, as soon as 2017, two types of litigation avenues before the courts in the event of a breach of this duty of vigilance. First, it created what we call a preventive litigation avenue, where any person who has a locus standi may enjoin a company to amend its vigilance plan if such plan is not complete enough, with penalty payment if necessary, which would be granted by the court. And the second litigation, which was created by this law, is a recovery litigation, liability claims, which can be brought before the courts and where the victim of alleged violation of human rights, for instance, may seek for damages before the mother company. So at this stage in France, we have 4 litigations which are pending before the French courts on the basis of this law. 3 have been initiated by NGOs on the basis of the quality of the vigilance plan, so on the basis of an injunction. 2 against Total Energies, 1 against EDF, 1 against Suez. And there is 1 pending case, which is already a civil liability case and which affects Casino due to acts of deforestation committed in Amazonia. And we have also currently EDF, Orano, Yves Rocher, and McDonald's who have received formal notices from NGOs before court actions on the basis of this duty of care law. And these are based on various actions and grounds, from climate breach to labor law violations to access to water. So you can also see that there is a multiplication of these litigations, but also a diversification of these litigations in France. So these litigations, they give rise to multiple questions legally, and those questions are highly critical for our clients. Again, we could talk about them for one single webinar, but we have chosen together to tackle upon three of these major questions. The first one, I have already discussed it a little bit, is the definition of the exact rights which is protected by this duty of care, and in particular the human rights, which were not defined by the French legislator. The second major question, which is before the courts today in France, relates to those who will be considered as having locus standi, which means an interest to bring a legal suit, and in particular, whether all NGOs are admissible to initiate such litigation against parent companies in France, including those who in their own countries would not have had such interest to act, given that, yet again, the wording of the French law is very large and says that all persons who have an interest to act may act before the French courts. And the third critical questions that I wanted to discuss very briefly is the burden of proof of the causal link between the damage and the alleged breach of the duty of care in the liability cases, because this French law actually assumes, contrary to classic French standards of civil liability, that it is not for the victim to demonstrate that the damage which it alleges occurs due to the lack of vigilance of the parent company, but rather for the parent company to demonstrate in court that the damage would have occurred irrespective of the preventive measures that would have been implemented. So the debate in France, which is a very hot debate and which would have high practical consequences for the French major groups, is whether, in fact, this French law created a vicarious liability upon the shoulders of the parent company for any acts or omissions of its whole supply chain, because in practice, you can imagine how difficult it is for this mother company in France to overturn such presumption of breach.
Thanks so much, Mario. I am very surprised because at the end of the day, the feeling I have is that the European jurisdictions are becoming, the guardians of universal justice. So, it's not enough for you, for a French court to have jurisdictions for a French company, but now, any victims of a damage of in the Amazon or in Brazil or in Africa
Absolutely.
can pursue an action before the French court saying that the French company did not do the due diligence of the local operation in Brazil. So
exactly
it's quite interesting.
That is
so
what's happening today. Yeah.
Yeah. So Anna, I'm gonna turn to you. So how do you think this reflects in the UK? Do we have like the same kind of experience or legislation?
I think in terms of the legislation, it's fair to say there is no equivalent to the French law. I mean, the French law, as Mario's pointed out, it requires businesses to identify and present risks to not only human rights, but also to the environment. I mean, the equivalent that we would have would be the Modern Slavery Act, but this encompasses only kind of one fraction of what the French law does. And really, the Modern Slavery Act, it predates the French law, requires a company to put an annual statement out saying what it does or doesn't do to prevent modern slavery in its supply chain. This applies to UK companies and companies operating in the UK above a certain turnover. But really, there's no bite to the Modern Slavery Act in terms of litigation risk. I mean, we're talking today about what companies should be worried about. And the Modern Slavery Act requires you to say what you do or don't do. So it's enough for a company to say, I've done nothing, or it's enough for a company to say, I've just started out my investigation. And the last thing I'll say on it is that there is no proper enforcement process. So the Secretary of State can require a company to produce its statement, but it's never happened to date. So really, there's discussions in the UK government about imposing financial penalties on modern slavery non-compliance under the Act, but it's very slow progress. And I think the answer is simple. We fall very short of the French position in terms of legislation.
But Anna, it is still a very hot topic for UK parents or subsidiaries in the UK. So can you tell us, what are the main UK litigation risks for companies, even though it is hard to enforce the UK Modern Slavery Act?
Yeah, I mean, I think that the main concern for companies in the UK or operating in the UK at the moment comes from the courts. So I can talk to three kind of really simple examples which illustrate why companies need to be properly managing and supervising their overseas and extended operations. The first of these is a case called Vedanta. Now, some of you will be familiar with this case. I'll touch on the facts very briefly, but in short, it was a claim brought by 2,000 Zambian claimants, so a mixture of individuals and communities, against a parent company, Vedanta, and its subsidiary, KCM. Now, the claimants alleged that a copper mine, which was owned by the subsidiary KCM and operated by KCM, had discharged toxic waste in the local community and caused mass environmental harm. Now, a claim was brought in the UK courts, and whilst it was not surprising that the court held that the subsidiary owed a duty of care to the claimants, it also held unanimously that Vedanta, the parent company, held a duty of care to anyone affected by the acts or omissions of the subsidiary. And in coming to its conclusions, really the court looked at whether the parent company had assumed responsibility. So had they intervened, supervised, controlled the operation of the mine in some way. And they looked at public disclosures made by the parent company, and a really compelling indicator of intervention was that public sustainability reports. So you may be thinking, why is this relevant in the supply chain context? That's the parent subsidiary relationship. And the point is that the same principles that the court set out in Vedanta can be applied to other triangular relationships in the supply chain context. So the court specifically said, this is not novel, these are generic principles. Logically, they can apply to other relationships. So the relationship between a company and its suppliers. And there are many parallels to be drawn between the way that a company interacts with its suppliers to how the parent controls a subsidiary. So, you often have companies, particularly large brands, in their contracts with suppliers, having a code of conduct or requiring particular standards on health and safety or labor controls. And you've often got the company monitoring and closely supervising its suppliers. And thirdly, you often have companies making very public statements about their suppliers. And so there are real parallels that can be drawn. And the second case I want to talk about shows exactly how claimants are using the principles in Vedanta to bring claims which extend to a company's supply chain. So this is the Dyson case. It's at pre-action stage, but it's a really important case because these are claimants which are migrant workers in Malaysia, and they are bringing a claim against Dyson's UK subsidiaries for harm that happened whilst they were working in a factory not owned by Dyson, but just part of Dyson's supply chain. And what the workers say is that they were subject to inhumane conditions, exploitation, forced labor. And the claimants are relying on the principles in Vedanta. They are saying that Dyson assumed a responsibility for those workers, even though it didn't own the factory, and therefore owe those workers a duty of care. So that's going to be a really interesting case to watch, to see how the UK courts think about extending that type of liability. And finally, a slightly different case in a completely different context is a shipping context. And this is the Moran case. And in this case, you had Mr. Moller, who was a man that worked in a scrapyard in Bangladesh, and he sadly fell to his death and died. And his widow brought a claim against a UK company, Moran. Now you'll be thinking, what does Moran have to do with a scrapyard in Bangladesh, and why would it potentially owe a duty of care to Mr. Moller, who sadly died? And the answer is that Moran sold, on behalf of the vessel's owners, the vessel to the dangerous scrapyard in Bangladesh. And Moran said, we can't owe Mr. Moller a duty of care. We have no contractual relationship with him. We never knew him. And the English Court of Appeals said, actually, you, Moran, UK company, in selling that vessel to that scrapyard, you knowingly created a sense of danger, a situation of danger, which was exploited by a third party, and you therefore assume a duty of care towards Mr. Moller. And I think that's, you know, all those three cases really give a really clear indication of where the UK courts are going and how willing they are to hold UK corporates accountable for harm that occurs far down a company's supply chain.
Thank you very much, Anna. So it's interesting because in this last example, it's not even the supply chain, it's kind of the value chain, because it's just someone you're selling your scrap to. Yeah. And basically the judge is saying, well, if you are using someone in that country that is creating value to your business, you are also liable. And that's how far it goes, really.
And this is what is taken into consideration under the directive, which we will talk about.
Exactly. I'm just gonna be very quickly, and I was asked, because I know there's a lot of Brazilian colleagues in this seminar. I was asked to very briefly take a look at what is the situation in Brazil, but that's not because I am Brazilian or only because there's a lot of Brazilian, but because Brazil became, in England and in Europe, one of the biggest clients of those class actions. And basically today we've counted more or less 10 class actions relating to Brazil, which were initiated here in Europe against, you know, different other companies. And when people ask me about, you know, what is the scenario for Brazilian companies here in Europe, I would say we have like 3 stages of arguments, of grounds that were used by the victims on those class actions. I think everything started, I think the first big case was BHP. So, you know, the Mariana Dam collapse, and so the case of the victims of São Marcos, which was brought in the UK against BHP, because BHP had, an influence, a duty of care, because it was in the joint venture. So I would say like the first stage of the arguments of those claims in Europe is the duty of care and the power to intervene. And it is a corporate argument, which means you are being sued in London or in the Netherlands because at the time of the damage, you as a shareholder or as a partner in a joint venture, you could have had a corporate influence. You had a duty of care as a shareholder, as a partner. So that's the first stage. And suddenly, those class actions, those victims started to realize that if this was to be the argument for Brazil, there wouldn't be a lot of cases that could be brought in London or in Europe, because there were not so many, holdings of Brazilian companies causing damages in Brazil. So we needed to think about something else. And so I would say the second stage is where some of those claims started to be brought in the UK and in the Netherlands and in Germany under the argument of the indirect polluter concept. And that's a super broad concept. That's a very difficult, complex, but it's a Brazilian law complex. And most of those claims are being brought in the Europe under Brazilian law. So it's for the English judge to interpret that. And do you imagine, it is already difficult for a Brazilian judge to interpret what is a direct polluter. So do you imagine an English judge which is faced with this concept? But basically, to be very simplistic here, it means that anyone in Europe that has contributed financially for the damage caused in Brazil can be held liable here, which is quite exaggerate, because we can see that even if you are a minority shareholder, or if you are a bank, or if you are an investor, or if you are, a venture capital putting money in an ESG sensitive operation in Brazil, you might be held liable under the indirect polluter argument. To be very clear, these arguments are still being litigated, are still sub judice. I can't say today what's going to be the result of the BHP trial, which was a couple of weeks ago, or I can say what's going to be the result of the different actions brought under the indirect polluter concept. But just to let you know, those cases have been brought and clients have been served here. And some of those clients in Europe are not holdings of Brazilian companies. They are subsidiaries of Brazilian companies where, because of the indirect polluter concepts, they can prove, or they are trying to prove, that there was money sent from here to Brazil. And so indirectly, that money contributed to develop an activity that caused harm. And final, which is going to be the third and most, I would say, stretched stage, is the supply chain, which is, well, now, not only if you have a corporate interest or a financial interest, but if your supplier is in Brazil and your supplier in Brazil committed a damage, in environmental damage, governance damage, antitrust damage, you might be held liable in Europe if you, as the buyer, didn't do the proper due diligence to check if your Brazilian supplier is being complying with ESG rules. So I would say those are the three stages, and they will probably be brought, and this is going to happen. It's just a question of time. And just to reinforce that, is the trend of this very, very prosperous funding industry that has a lot of money and is around and very interested in looking at these cases. So just to give you a very, very, short perception of Brazil, and I will give I'll give the floor now to Mariode, as I think she has a question to Nicolas.
Yes, and just before that, just to follow up on what you just said, this is really happening in France. The casino case is exactly that. It is acts of deforestation in Amazonia, allegedly committed by a distant supplier of casino. And the case is before the French courts against the mother company of casino for acts of deforestation by a supplier of the group. So this is exactly one of example of something which is already happening, based at least on the French standard of the duty of care. So Nicolas, question for you. You work at FTI Consulting with corporates to help them manage this supply chain risk that we are talking about. Could you please tell us what do you see them doing to manage such a hot, now a large risk?
Yeah, definitely. So, I mean, I guess I would say I see differing levels of activity across the board. So some companies are all over this, whereas some are not really doing very much. And so in terms of my answer, what I'll go with is what does good supply chain risk management look like, and managing that risk throughout the supply chain. And it comes down to some key building blocks. The key building blocks of any good compliance program you can then apply to supply chain risk. So firstly, thinking about governance. What policies and procedures do you have in place for that supply chain? It might be a code of conduct for suppliers. It might be access to their whistleblowing policy, and other ethical business practices like your bribery and corruption policy. Obviously, it's all around tone at the top. So in your own business, you'll have your own tone around what's accepted, and really that should be flowing through, but also thinking about roles and responsibilities within your business, who's looking after supply chain risk, who's implementing that overarching supply risk management program. So there's governance. Then there's risk assessment, which is really important and goes to some of the things that you've all talked about. Understanding the risk of your supply chain to your business. So it could be modern slavery, it could be environmental damage, it could be something like conflict minerals, but looking at that risk profile across your supply chain. So mapping out who you're doing business with, getting information from them, questionnaires, building a response program based on those levels of risk, because you need to do more with the riskiest suppliers. It stands to reason. And then the third topic Daniel's spoken a lot about is due diligence. So having a program of due diligence where you are using screening tools to assess the key risk factors, whether you're onboarding or whether you're doing ongoing monitoring of your supply chain. You need to know whether there's adverse media, whether there is litigation risks, there might be sanctions against them, or there might even just be integrity due diligence type issues with individuals in the business. So again, using due diligence as a tool to know who you're doing business with and what they're doing. And following on from due diligence, monitoring, having a monitoring program. You need to monitor your own success in-house of how you're managing your supply chain, but you also need, for probably the more risky suppliers, to be on the ground doing audits, visiting their sites, understanding what they're up to, and proactively getting them to fulfill KPIs so that you can monitor their progress. And I guess finally, if things do go wrong, and things always do go wrong within supply chains, being able to investigate things that go wrong and take action. And that might be to cease relationships with non-compliant suppliers and terminate them. That is definitely the most extreme case. I would say even better, creating a remediation plan and working with that supplier so to make sure things like that don't happen in the future. But I guess what I've outlined, I'll summarize with, is that clearly not everyone can do all of these things, and that's definitely the case. And I would say sectors like consumer goods and manufacturing, in my view, are those sectors that traditionally have done a lot more work in this space. And that's probably because of operational reasons, because they need to know where their goods are coming from. In the consumer goods, in the food industry, it's really important to understand your supply chain in a lot of detail, because you need to. The same with manufacturing when it comes to parts. So yeah, a lot for businesses to think about in terms of managing their risk.
Thank you very much, Nicola. Just before we go on to Mario, there's a lot of questions. So first, I would like just to confirm. I think the answer is yes, but a question from Paulo Mont. So the liability on those cases is a tort law liability, right? Because, or in the case of supply chain, it might be based on the contract. I think it's probably a law upper legis, like you say. But if you have any different answer, just let me know. Frederico Favach is just asking if Mario could share the French law number or name. Just it can be afterwards. Russell Hopkins is just sharing a very interesting point. Maybe, I don't know if Anna wants to comment on the Vale case. Thank you for the excellent panel discussion. Perhaps also worth mentioning regular action potentially misleading ESG statement. That's some sort of greenwashing, maybe, which was the SEC case against Vale, and I will share with you all the link to the SEC judgment, which is public. Anna, do you want to make any comments?
I can make a few comments on that. I mean, I think, one of the causes of the parent company cases that I talked about is really that companies make statements, which they have to, they're under consumer and investor pressure to put out statements on what they're doing. But then it's really important for those statements to be accurate and for those statements to reflect the reality. And I think that's important in the context of a negligence claim, because as we know, statements that weren't correct have resulted in liability there. But I think there's also another side to the picture, and that's what Daniel says. It's greenwashing claims. I mean, we're seeing more and more claims being brought principally against energy companies, but European energy companies, for misleading ESG statements. So that might be in a climate-related disclosure, that might be to investors in a prospectus or in a memorandum, or it might be simply in advertising. Claims are being brought under the advertising standards. So I think it's really important for companies to have a look at what statements are going out, and, you know, making sure that, to Nicola's point, making sure that there's real kind of oversight over the statements and actions that a company is taking. And then step two is making sure that, you know, if you're putting out public disclosures, making sure that they're accurate, because otherwise you expose yourself to a number of risks, and particularly claims of misleading statements and greenwashing.
Thank you very much, Anna. Turning to Mario, so let's talk a little bit about the EU directive finally. So what is this about, Mario, then? And you know,
and I will maybe then respond to the questions which were asked regarding French law afterwards, then, Daniel.
Yeah, absolutely.
Lots are coming, but one of them is regarding French law cases which would be already against board members or investors. So I guess we can talk about that just after the directive, because I don't know if that's good news, but the directive also is now creating an express obligation upon DNOs. So there's only one step from DNOs to investors and shareholders. So what is new with the EU directive? For French people, not a lot, because this directive was largely inspired by the French duty of care law. But for pretty much all other member states, a lot is new and a lot is coming. This directive is currently negotiated, and it would then create a duty of care upon many companies in the European Union or acting in the EU market. And this will, in fact, to answer and follow up on Nicola's intervention, it would aim at standardizing the preventive measures that are expected from these companies in Europe globally, instead of leaving it to each jurisdiction and each member state. So that's also a very major ambition of this directive. So the scope is in fact larger than the French duty of care. First, in terms of companies which are targeted, the directive aims at putting this duty of care upon the shoulders of all companies based in the EU with more than 500 employees. You see, in France, it's more than 5,000 employees, huh? So that's a lot more companies. 500 employees with a worldwide turnover of more than 150 million euros. But very importantly, it also targets smaller companies with only 250 employees and 40 million euros of turnover, if they operate in a sector at risk. Nicola, you were mentioning those sectors, but the directive is listing what it considers as a sector at risk. It includes textile, notably mining, agriculture, fishing, and timber trade. So let's be very careful, because here we are talking about small companies and way smaller than the major multinational companies, which up to date internationally and domestically have been targeted with this duty of care obligations. And to give you a very practical idea, up to date, a study which was carried out by the European Commission shows that 13,000 companies registered in the EU at least would be considered and would be subject to this new regime. The directive is also broader in terms of scope regarding the obligations than the French law, because the project is to protect sustainability, human rights, climate change, and environmental issues. So that's comparable to French law, but And as you mentioned before, Danielle, the directive is now looking at the value chain and not only the supply chain. And that makes a major difference in practice. The value chain indeed is not only your subsidiaries in the world, not only the suppliers and subcontractors with which you have an established relationship. You can see here that the directive took the same standard as the French one, and by the way, did not define what is an established relationship. So that will be a lot to say and a lot, obviously, to litigate in court upon this only concept. But it also targets then the business partners. And that is referring to what you were expressing, both of you, Anna and Danielle. The business partner in your value chain can be your customers. This is what we are talking about. Can be your joint venturer, can be pretty much every entity which has contributed to create value to your company. So that is a very larger scope. A very interesting innovation coming from this directive, if it is issued, is also that the creation of an independent authority in each of the member states, which will be in charge of controlling the quality of the vigilance plans, which are going to be required now from those European Union companies. And globally, this authority will be in charge of looking at your compliance with all of the obligations contained in the directive. This is also very much of a hot topic because we all know that having courts on the one hand, but also an independent authority looking at your compliance obligations is another role to play. And last but not least, and this is coming indirectly to one of the questions which was raised, is that the directive expressly holds directors and officers liable, and they will now have to take into consideration the consequences of their decisions on sustainability, human rights, climate change, and environmental issues. So this is coming. As you may already know, under French law, at least, I think it's the same under the UK law, there is anyway a possibility to consider that a shareholder or even an investor is liable for instance, a human rights violation as long and as soon as it has contributed to such a violation. So this directive would enlarge the possibilities for DNOs and maybe board members as well as investors to be held liable. There's lots more in this directive, but given the time already, I will stop it there. Danielle.
Yeah, and I just a quick point on the directive, and then I'll hand back to you, Daniel. But it's really so significant because it levels the playing field for companies, not just European companies, but as Mario had said, it also applies, I think, to something like 5,000 non-European companies.
Absolutely, yeah.
And that's huge because, you know, most of these companies will not comply. So it's really leveling the playing field, and I think it's going to have a really significant impact. So it's really important to understand it now and watch out for it. Daniel's over to you.
Yeah, thank you, Anna. So yeah, exactly. Even if you have like an office or just, you know, a headquarter or a small operation in Rotterdam or in Germany or whatever, it applies. So it's very important. So I will directly go to Nicola now, as we are running out of time, and I think we need some more inputs. And I will ask her, Nicola, considering what you said, could you maybe say that at the end of the day, for a lot of companies, it's better to do nothing, or it's better to take some action at least? Or so, what's your impression about this, considering how new all this is?
Yeah, I mean, I think it'll be clear to everyone on the line that there is tension between that litigation risk and actually taking action throughout the supply chain. And you know, in the last few years, there's been this really sharp increase on the focus on ESG, ethical, transparent business, and being responsible. And that comes from all angles, consumers, wider civil society, investors, employees, shareholders, etc., etc. And with this in mind, companies can't simply do nothing because stakeholders expect them to take action. Reputational damage of getting things wrong and acting irresponsibly is really high, and you know, we talk about class actions, and we also think about things like cancel culture, which is huge in current society. You know, there've been a lot of recent corporate scandals that demonstrate that. So you have to be a good corporate citizen, and it means taking responsibility not only for your own business but the actions of your extended business, your supply chain. And you know, we've talked about the UK Modern Slavery Act on this call. That is based on exactly that principle, the need for big business to take responsibility, set an example, and deal with you know, what is a huge global issue in modern slavery. So that was the long answer. The short answer is you can't simply get away with doing nothing, because the reputational risk is huge.
Thank you very much, Nicola. And just as a, you know, complementing this first question, what are the specific areas of a company that you think we need to think about when it comes to third-party risk and supply chain activities?
Yeah, well, I think probably two main things, both of which have been discussed today. So firstly, that whole piece around due diligence. So I always say to my clients, can you answer the question of, do you know who you're doing business with, and do you know exactly what they're doing on your behalf? Could you answer the question as to whether they act with integrity and they act within the law and that they have a good track record? Due diligence will get you a long way to being able to answer those questions. And probably linked to that, does your supplier know what your culture is and what your expectations are of them? I also always talk to people about the risk of their own suppliers subcontracting, because I've worked on a number of investigations around this, and it typically is where there have been, the suppliers have subcontracted, that's where the issues have arisen. You know, it's the unknown factory down the road who hasn't been vetted, who ends up making your goods, and those are the things that cause problems. So that whole piece around due diligence. And then the second one very quickly is reporting. Like, if you are going to report anything externally, how comfortable are you that the information you're reporting is good information, that it's correct, that it can be supported? Because the risk of greenwashing and misreporting is huge, and people rely on those reports increasingly to invest and make other decisions. So
thank you very much, Nicola. No, thank you. We have an excellent question for you, Nicola, on the chat from Giulio. And Giulio was also an in-house or very, very long years in a multinational with a very strong parent company in Europe. And I will simply read his question because it's I don't want it to lose any sense. So today, with the use of technology, it's possible to monitor the financial, reputational, and legal risk of third parties in the supply chain based on big data. This is kind of a background check that goes deeper than a simple risk assessment based on check the box, quote, question in a form usually applied by the third-party compliance common programs. Have you seen parent companies in Europe, Nicola, taking such preventive actions on their supply chain in jurisdictions outside Europe to establish a broader risk profile?
Yes. Absolutely. I think I sort of alluded to it before when I talked about due diligence and also linking it with risk assessment. So once all that data has been gathered, like the self-reported data through questionnaires to assess the initial risk of that supplier, and you say whether they're high, medium, or low, that ongoing due diligence, so using technologies that pull data from all over the world. And you know, I have a really good real life example of working with a client in Europe in the life sciences business who did due diligence on a third party in Malaysia, and they using technology like that, they found some information that they just never would have picked up. It was in a blog. The technology picked up a blog in Malaysia where people working in a supplier factory had had their passports taken off them, and they were working in horrendous situation, and it was forced labour. That would never have been picked up other than through very, very detailed, deep due diligence.
That's a really relevant factor that the courts are going to take into account is, you know, what have companies been doing and how long has it taken to find this social harm in your supply chain? So I think, you know, the processes that Nicola's talking about, I think they're really key to make sure that there's a quick response, because in the Dyson case I mentioned earlier, I mean, one of the allegations there is that the company just sat on it too long. You know, they knew there were issues and they sat on those issues. And actually, I think, you know, there's good arguments to say if you find out about an issue and you address it, then, you know, you're not breaching your duty of care. And so I think that quick response and having the ability to do that is really key.
I think it's about being proportionate, because you cannot know and will never know everything that is happening in your supply chain. But my view is if you have the framework in place and you can demonstrate that you've done due diligence, that you've risk assessed the suppliers, you know, that you've gone and done third-party audits, that is such a much better story when things go wrong than if you've done nothing at all. Going back to the previous question from Daniel, actually.
I fully agree with you, both as former in-house in charge of litigation and as now again back in practice, and in fact on that topic we do encourage our clients, which are those in the middle, in the gray zone, because one of the multiple questions which arose under the French law is whether you are subject to the regime or not, because it was not so clear for some companies, and for those our recommendations were always, you know what, prepare, at least get ready. So if you do not want to publish a vigilance plan because you consider that you are not subject to the duty of care, then at least take the measures internally, do your mapping of the risk and take your measures, have something in written. So then if you have a control or if the court is in front of you, you can show that you have done everything, but just you haven't published it because you were not so sure that you had to publish it. So that's in line with what you recommend, Nicola. Always being more cautious than the other way around on this duty of care, because they have major consequences.
Thank you very much. Well, we have a final question, which is also, you know, related to the insurance market, which is very, very hot here in the UK. There's an insurance for almost everything you can imagine. So, question for Mario: do you think we can insure that supply chain risk, or you know, the parent company liability risk more generally? Is this something you've seen?
Well, yeah, it's a very, very hot topic as well in France, even though I'm not sure we have as much insurance as you guys in the UK. Well, yes, in my experience, and at least under French insurance law, those damages which are the ones which would arise from a breach to the duty of care should normally be covered by what we call the third-party civil liability insurance policies. But why is it anyhow an issue, or at least a question in France? Is because, as you all know, a risk is only covered by your insurer if it occurs due to hazard, right? And not if it occurs due to your own actions or actually inactions. And that also goes in line with what Nicola reminded everybody, is that if you has done nothing, or if you has made a vigilance plan which is grossly insufficient, or just if you have implemented some marketing statements but not, you know, something very serious, at the end of the day, what is considered to be a risk regarding the insurance is that the insurers could defend that the damage would have occurred inevitably given your negligence, and if your negligence is grossly enough, it could go up until maybe alleging that it is not only a gross negligence, but maybe a willful one. it depends how you see things. So that is not yet something before the French courts happening, but we do encourage our clients to take that risk of not being covered by their insurance. And why is that? Because in France, obviously, because it's since 2017, insurers have realized the financial magnitude of what we are talking about here. Again, we are taking, the law says, and this is also in the directive, we are talking about a damage which would be a severe impact on human rights or environment. A severe impact means not a classic commercial damage, but potentially, if we look at the casino case, and if they are held liable at the end of the day, we are talking about the deforestation of Amazonia. So insurers are looking at this, and all what we know, Danielle, is that some of them have already started to renegotiate their insurance policies, looking at these new types of litigations coming and this new civil liability risk, which will be in the coming months and years higher and higher, with the NGOs being very active. And as you said, particularly active in France, because the Cour de Cassation, which is our Supreme Court, decided in March, so just a month ago, that the law which should apply to the question of the locus standi is not the law which would apply to the NGO where it is registered, but the French law as being the law of the court, which will decide. So you can see that it opens what we call the forum shopping, where NGOs will definitely have a good interest to run before French courts, including and especially those who would not have had the same option in their own countries.
Thank you very much, Marion. We have two questions. I think one which can be answered quite quickly, which is by Oscar, which is what's the timeline, maybe Anna, on the EU directive, or Marion, Anna, who wants to answer that, and if you think this is gonna go through, which is a good question, because we might be discussing something which at the European level might not be approved, but it will definitely influence national legislation. But what about the EU directive? Any ideas of timeline?
I would not know, because it's always very slow, and the negotiation of every directive is usually very slow. So I wouldn't really expect that if it's coming at the end of this year. But in terms of whether it is going to come, my personal opinion is as it is, because it's strongly pushed for. But the major debate today is in between, let's say, the French perspective and the German way of looking at things, and especially on this question of interest to act. And that might take an additional couple of months to get all of the member states in agreement, because these are very different regimes. The French one, which I have reminded, is very, very large in Germany and in many other European countries. An NGO cannot act for herself as in defense of a collective interest. It has to have a power of attorney of a victim, which is very different. And so that's one of the major questions which might slow up a little bit the process.
Thank you, Marion. We have a final question here from Thiago Cardoso, which is an interesting one. Let's say, a parent company or the buyer in Europe is convicted and is charged for damages caused by its affiliate or by its supplier in Brazil. Is it possible that this European company then have a recourse against the supplier or against the affiliate in Brazil, which is a common action for insurance, for example, against the one causing the damage? I don't know who wants to answer this, maybe under the French perspective and the UK perspective very quickly.
I mean, I can give the UK perspective quickly. I mean, it's a really important question. It's obviously a very practical question. If you face this situation, what can you do to minimize your liability? Everything in terms of a UK perspective is going to turn on that contract that you have with your supplier. So it's really important to make sure that you've got the right terms and conditions there. You should be looking at things like limits of liability, and whether there's any restrictions on indemnity claims. But in principle, certainly as a matter of English law, you know, it's a valid claim to have against your supplier. And the question then will be about foreseeability. So how foreseeable was the European penalty when you entered into that supply contract? But there's no reason why you wouldn't have a claim there from an English perspective.
Yeah, it's exactly the same under French law. There is no reason why a supplier or a subcontractor, which would be, let's say, directly responsible for the damage, should not be called by the mother company, which is in front of the NGO, subject, of course, to the classic conditions for such call of guarantee. And the former in-house that I am will also recommend, of course, that the first thing you do is to call your insurer and to make sure that whatever happens is hopefully covered. And that includes DNOs and personal liability issues if it comes, at least in France, DNOs, but I know it's the same in the UK, are also covered for their potential liability. So it's either you are a director or a board member or a company. In any event, if this is coming, make sure that you are covered at the end of the day.
Thank you very much. Well, I think we are almost at the end. I thought about just, you know, improvising very quickly at the end to surprise everyone, but maybe if you could each, you know, Nicola, Anna, and Mario, give, you know, a last minute recommendation for a client on that topic, you know, what would that be? I know it's, you know, a short recommendation, but what's the main point to, you know, conclude this webinar if we should get like just one idea from that? Maybe Nicola, yeah, go for it.
Yeah. Well, I think it's like sit back and take stock. What are you doing? Like really be clear with yourselves. Like what are you doing in this space? And honestly, ask yourselves, do you think it's enough?
Thank you very much. Anna, maybe?
Yeah, I would focus on a specific point. I totally agree with Nicola. I think, you know, look at the public disclosures that you're making. Look at your modern slavery reporting. Look at your sustainability reports. Look at your climate disclosures, and, you know, make sure that they are up to industry standard, and then make sure that they are focused on purpose rather than outcome. And I would really have a great understanding throughout your whole group about what public statements you're making about how you're managing overseas operations and supply chain activities.
Thank you, Anna. Mahyod?
Yeah, I share absolutely everything Anna said. And I would probably say, taking one step forward, that companies should, according to me, take this duty of care as an opportunity rather than only a constraint. You know, there's this English adage, it's not a French one, which says, if you think compliance is expensive, try non-compliance. I like that one to sum up what we've said. And more seriously, what we've seen on the other side is that when you take this as an opportunity and you deliver this message to your teams internally, and everybody's looking at the purpose of what it is doing, it is something which is a virtuous circle. You can win tenders today in France, obviously, if you are a sustainable company, and you will win against those who think that this is really something which is a constraint and they don't want to make an effort. You can also sell your company easier because now everybody who is acquiring a company is looking also at the measures which we're taking internally. So to conclude, I would probably recommend to take this as an avenue to you know, think about profitability versus you know, human rights protections and the purpose of what we are all doing in our activities.
Thank you very much. Well, I think just to conclude, you know, I'd like to first of all thank all the panelists, Nicola, Mahyod, Anna. I think if I could just say just a couple of few words, final few words, ESG for a very long time was just a very beautiful abbreviation which companies would use to convince shareholders that they were doing the right thing. Now, it's a concrete ground used on filings of concrete actions which are being brought in Europe against companies. And they are costing a lot of money for those companies. They are stimulated and they are incentivized by a very, very wealthy funding industry and by a number of victims that want to come to Europe to get a better, maybe a more efficient judiciary, or maybe more attention from a PR point of view, sometimes with the sole purpose of kind of settling the case and making and trying to make some money. So there is a reverse engineering mechanism today where the most important thing is to find the defendant, and then we see how we can convince the judge that the defendant is there is jurisdiction. And so I would say, I don't know if you agree, but I would say like the EU directive is just another tool to kind of try to find these anchor defendants in Europe for damages caused in Brazil, for damages caused in Africa, etc. So I'd say if you have an operation, if you have an office, if you have, a branch, if you have a buyer in Europe, whatever you have, if you have an activity that generates ESG sensitive activities, take care, because there will be there will be someone thinking about how I can sue you in Europe and not in Brazil. So on that, I just wanted to really thank you, everyone. It was, great. The turnout was amazing. And I would like to, on behalf of Nicola, Anna, Maryode, make ourselves available if you have any questions, for Nicola, for Maryode, for Anna and me. Just send us an email. Would be absolutely happy to answer. And I thank you so much, our guests today, and I hope you have enjoyed. Thank you so much.